Ladies and gentlemen, welcome to my last planned video on filming military installations. I'm sure I'll return to it at some point, but there are a lot of auditors getting arrested for stupid stuff recently, and I'd like to be covering some of that to keep it from continuing to happen. Let's get started. Did you know I made that myself? Music and everything. It's pretty good. I like it. It doesn't matter. It's not relevant. It doesn't matter. Let's move on. On April 30th, 2019, the owner and operator of the YouTube channel Accountability Media was outside of the gate of Joint Base Myer-Henderson Hall in Arlington, Virginia. The video starts with the filmer approaching the gate and reading the signs out front. If you've seen any of my videos on filming a military installation, you'll know that the base has to be restricted, confidential, secret, or top secret for the filming to be prohibited by law. You'll notice that the sign has none of those words on it and does not state that filming is prohibited. You might also notice a spelling mistake right here. Although it doesn't explicitly state that the base is restricted, the contents of that sign are a pretty good indicator that it might be. Mostly the part about strictly controlled entry. Can any member of the public enter? No. Then technically it's restricted. But also technically, filming is only prohibited if the President, the Secretary of Defense, the Secretary of the Army, the Secretary of the Navy, or the Secretary of the Air Force has declared the base restricted. Not as simple as you thought, right? At 3 minutes and 20 seconds in, the officer asks the filmer if there's a reason he is filming, and the filmer states that there isn't one that he needs to know. Wrong. If you aren't filming as a source of news, which only requires an audience and a message being conveyed to them, then you are not protected by the First Amendment's freedom of speech. If you aren't filming to petition the government for a redress of grievances, then you aren't protected. If the thing you're filming could not be reasonably considered important for the public to be aware of, it isn't protected. If you fail to articulate that you are recording for one of those reasons, and it is unreasonable for an officer to believe that you are filming for those reasons, then the officer has a lot more freedom to stop you, detain you, and or arrest you, since he isn't violating your First Amendment rights. Since the filmer posted the video in violation of 18 U.S.C. 797, we know that he had a message and an audience, making him a protected news source. But the police wouldn't have known that, since, of course, the video wasn't uploaded at the time he was filming it, and the filmer gave no indication that it would be uploaded ever. But the Supreme Court said... The Supreme Court hasn't said anything. The highest a ruling has ever gotten regarding your right to film police are federal circuit courts. Virginia's circuit court, which is in the 4th District, doesn't appear to have touched this one yet. I told you it was complicated. Ultimately, what all this comes down to is whether or not the base was restricted in accordance with the guidelines set in Executive Order 10104. If it was, then it wouldn't matter if the filmer was a news source. It is still illegal to film a restricted military installation. The filmer brings up a very good point during the video. He asks if the officer is able to detain him, under the assumption that his jurisdiction is limited to the federal property of the base. The sign states that the fence marks the border of the installation, so we can assume that they are not on federal property. As far as concurrent jurisdiction, that just means the officer has permission from the county or state to enforce the laws on and off the federal property. And since he is civilian law enforcement employed by the Department of Defense, there's a very real possibility. On the other hand, military law enforcement consisting of active duty military members cannot have concurrent jurisdiction, except for extreme circumstances. Generally, if they tried to enforce the law outside of federal property, they would be violating the Posse Comitatus Act. So, it is an important thing to be aware of when approached by military police or security forces. Meanwhile, in the video, the filmer is subjected to a Terry frisk, which isn't unusual. He's also asked for his ID, which he refuses to provide. Does he have to? Well, Virginia, the state where this takes place, doesn't appear to have a statute that would make it illegal for the filmer to not provide it. However, Arlington, the county in which this happens, actually does. The Arlington County Code actually states, "It shall be unlawful for any person at a public place or place open to the public to refuse to identify himself by name and address at the request of a uniformed police officer or of a properly identified police officer not in uniform, if the surrounding circumstances are such as to indicate to a reasonable man that the public safety requires such identification." Breaking the law is a public safety concern. So, I would argue that he would have to identify himself. At 13 minutes and 26 seconds in, a supervisor arrives and he tells the filmer that a congressional letter was issued, which states that you can film the exterior of federal buildings, but cannot film an access control point. I'm not aware of this letter, and nobody I've ever spoken to about it has ever heard of it. Unless, of course, he means the Department of Homeland Security memo that came out in 2010 and then again slightly modified in 2018. If that's what he's saying, then yes, that letter gives you permission to film the outside of federal buildings, but not the outside of military installations. If that's not what he's talking about, what on earth is he talking about? The officers give the filmer plenty of chances to stop what he's doing. They even tell him at 16 minutes into the video that if he picks up his things, stops filming, and walks away, then he's no longer detained and there won't be an issue. The filmer claims that if he is no longer detained and is free to go, then he's free to stay. And while that's technically true, the officers don't have an issue with him being there. The issue is that his filming is a violation of federal law. When the filmer makes it clear that he isn't going to stop filming, he is arrested for failing to obey a lawful order. The filmer is put into the back of a patrol car, and his bag is opened so that his camera can be put into it. This could be a legal issue. Now, at that time, the filmer was on federal property, which means that his property is subject to being searched. But does that still apply if he was detained on public property and put into a patrol car on federal property? I've looked through a lot of case law, and it isn't really clear. If the filmer wanted to press charges for an unlawful search, I'm sure that he could make a pretty good case. Regardless, after about 35 minutes of being detained, a detective arrived, who released him and had his items returned. I don't know why a detective became involved. I don't know why, in this instance, the filmer was in the car for 35 minutes. But if I had to guess, based on my experience, the officers were waiting for an Arlington County police officer to arrive to transport the filmer to their police station. Under that assumption, I also believe that it is possible that the Arlington police declined to become involved, which makes things kind of messy. If that's the case, then the detective was probably sent out to help sort everything out. Folks, this is pure speculation. But I have encountered situations like this before. So, why did the detective not charge the filmer with a crime? As someone who's worked as an investigator alongside Department of Defense employed detectives, I would consider it unlikely that the detective knew about 18 U.S.C. 795. It isn't a crime that usually reaches their level. Their areas of expertise are often more along the lines of domestic violence, or child neglect, or arson, or larcenies over $1,000. The detective even states that just because he can't articulate that a crime has occurred doesn't mean one hasn't. This whole video is like a really meh roller coaster of weird, and I can definitely see why, based on the officer's actions, especially after the detention, the filmer wanted to file complaints. If I had copies of the officer's statements, which would indicate what the reasoning behind their actions after the detention was, I would love to see it. But since I don't have it, I'd like to leave this message for the filmer. If you want to pursue a lawsuit, there are a few things you would have to establish. Do the officers have concurrent jurisdiction? Is the base restricted? Did opening the bag to put the camera inside constitute a search? If it did, was it allowed because of the security procedures of the installation, even though you were brought onto the federal property against your will? Why did the officers have you sit in the car for 35 minutes? Before I end this video, I want to go through some of the comments. Now, I always leave comments in the videos I'm about to do a video on, so that people can respond to me, we can have discussions, I can get the most accurate information. Hopefully, these comments I'm about to share with you will answer some of your questions that you might have after this video. Exhibit A, a conversation between myself and a person identifying as Michael Megabit. After misreading Executive Order 10104 a bit, he says the 2010 and 2018 DHS memos allow the filming of a military installation. Nope, it doesn't. In fact, I discussed this in part 1 of my audit on Johnny 5-0, the one where he's arrested outside of Edwards Air Force Base. If you want to know more about that, I encourage you to watch the video or ask me about it in the comments. Next, he says that 18 U.S.C. 795 doesn't apply to people on public property. So I tell him about Genovese versus the town of Southampton. In that case, a woman was detained for filming a military installation from a public sidewalk. She filed a suit against the town for violating her rights and actually won. However, her victory was not based on the detainment, and her own defense, after discussing the issue with a judge, could find no reason why 18 U.S.C. 795 did not apply to her. Remember, she was in public. Now, this case never made it past the Eastern District of New York, so it doesn't have much influence in the legal world, but isn't it interesting that a lawyer and a judge, when they put their heads and their many years of legal education and experience together, could not find a reason why she wasn't breaking the law? Isn't that kind of strange? Isn't that kind of interesting? Oh. This brings me to Exhibit B, A person identifying as Lead Wallet claims that the base isn't restricted, and he has the list of bases that are. I don't have that list. I've looked very hard for that list, and I don't have it. I want it. So of course I asked for it. He claimed I could just Google the list or go to the DoD site to get it. I've done a lot of Googling for that list. No dice. So I asked for a link, and he did not provide one. If that list existed, it would be in his best interest to share it, because it would completely destroy my argument, and I was nervous. However, he abandoned that topic and claimed, if you read the whole 18 U.S.C. 795 code, it must be enacted by the president, or a 2/3 vote from Congress. It was only used once, and it was after Pearl Harbor incident. It has never been used since then. Folks, I wish I could tell you how many times I've read 18 U.S.C. 795. Nowhere in it is Congress even mentioned. Yes, the president must declare the base protected for it to apply, but that's where Executive Order 10104 comes in. That executive order allows other people to declare military installation protected from the general dissemination of information. I have no idea what he's talking about with Pearl Harbor, and if someone could explain that for me, I would appreciate it. Now, Lead Wallet did say that I am correct, that Executive Order 10104 allows people other than the president to declare bases restricted, which is strange because that concession appears to invalidate his previous argument. So much for sticking to your guns. What worried me was that he claimed the order ended in 1953. Again, I got nervous. Maybe he was right. This called for more research, and I discovered there were two places he might be getting 1953 from. First, President Truman, the creator of Executive Order 10104, ended his presidency in 1953. However, executive orders remain in effect until canceled, so that couldn't be right. The second place is in the executive order itself, where it says 1949 to 1953. I actually thought he had me there, until I realized that 1949 didn't make sense. The order was enacted on February 1st, 1950. So where was the 1949 coming from? It turns out that those numbers are a reference to where the executive order can be found in the publication of the Federal Register. In this instance, it is a compilation of government regulations made between 1949 and 1953. And finally, Exhibit C, which comes from a person identifying as Roxboratom, identifying as Rox. After a short conversation with another commenter, he says that the Supreme Court allows the filming and has stated a person cannot be detained for more than 20 minutes. Now, hold on a second. We heard that argument in Part 2 of Johnny 5-0's Edwards Air Force Base arrest audit. Because it keeps coming up, I researched it. And I'm pretty sure I found the case they're referring to, which is United States versus Sharp in 1985. However, that case didn't limit detention to 20 minutes. It stated that 20 minutes was a perfectly acceptable amount of time. The Supreme Court even stated that if an investigation needed more time than that, then a detention longer than 20 minutes would not be unreasonable. A few more people decided to get involved in the discussion before Rock sent me a link to an article written by Stephen L. Arguriu? Just Stephen. Written by Stephen. He's apparently a senior legal instructor, and he writes, a common field rule used by many law enforcement agencies across the nation is the 20-minute rule. And in his citation for that, he states that the 20-minute rule is informal. That means it's not official. It's not a real rule. It's just sort of a suggestion. This informal rule is basically that if probable cause to believe a crime has been committed cannot be established within 20 minutes, then the suspect gets released. However, probable cause is established. He has a camera. He's pointing it at a military installation. It is recording. Bam! It meets all the elements. And let's not forget that right after that quote, in the same paragraph comes this one. Depending on the facts and circumstances of each case, 20 minutes may be found to be excessive, while 12 hours may be deemed reasonable. It's not a great argument when your own facts turn against you. Folks, if you're going to send me information that supposedly disputes my claims, read it first. Anyway, the auditor failed. He broke the law. But better luck in the future. If you have questions, send me a message on Twitter. Check out the original video in its full context. And if you enjoyed it, leave a like. If you enjoyed my video, please leave a like here as well. Until the next time, be good, stay safe.